Good day, ladies and gentlemen. Welcome to the Justice Chronicles. In this issue, we're going to be dealing with how to get the most out of your court-appointed attorney. Now, in American criminal legal system, everyone who's accused of a crime is entitled to have an attorney represent him or her. Now, if you have the financial means, you can go out and hire your own attorney and have that attorney represent you and defend you in court. But if you're indigent and you don't have the means, the money to pay for and hire your own attorney, then the court will assign an attorney to you, and that attorney will be paid by the state. This is the same state that is accusing you of the crime that you're being charged with. This court-appointed attorney's back is up against the wall. Depending on where he or she practices law and is practicing law, they could be juggling, excuse me, they could be juggling anywhere from 5 or 6 cases in some of the rural counties in New York State. They could be juggling dozens of cases in one of the 5 boroughs of New York City. And if they're juggling 10, 15 cases, they certainly do not have the time to dedicate to any one given case. And that's going to put the people that he or she represents at an extreme disadvantage when compared with the state that is going to have investigators, paralegals, staff attorneys, supervisors. They got a whole bunch of different eyes watching that case, making sure that that case is, they're working to prove your guilt. And you have an attorney that you have to share with 15 other people that's working to or supposed to be working to prove your innocence. So there's an imbalance right there from the beginning. And then you have some attorneys who, I hate to say it, but they just don't care. You got caught in the system. They're assuming you're guilty, and they're going to be looking to they're just going through the motions, and they're going to be looking to plead you out somewhere down the line. And if you're really innocent, then you need to get the most out of the attorney that's representing you. Whether you're paying that attorney or not, you need to try to get the most out of that attorney that's representing you. And we just want to go over a couple of things that you can do to try to get the most out of the attorney and hopefully get you out of your situation you're in. Now, the first thing you should do is when you get charged and you get arraigned, you have to be arraigned in court. You have to be arraigned in local court. So when you're arraigned, well, when you're first arraigned, you might not, depending on where you are, if you're in a rural part of New York, you might just be arraigned originally and you might not even have an attorney. And the judge will arraign you, and the judge will tell you that, read you your rights. You have the right to an attorney and all of that. Some judicial rights that the judge would read you, and the judge would let you know that he or she is going to make arrangements. If you can't afford to hire an attorney, they're going to assign one for you. And the next time you appear in court, that attorney should appear in court with you. And you should obtain that attorney's business card with that attorney's name, mailing address, telephone number, and email address. And you should let that attorney, if you know you have someone on the street that's outside that is in your corner or is willing to help you with your situation in terms of communicating with the attorney and working with the attorney and talking to the attorney, then you should let that attorney know. And as soon as you meet that attorney and you're getting that attorney's business card, you should let that attorney know, listen, my brother blah, 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 or my sister, or my wife, or my husband, or my friend, or my cousin, or whoever that person is going to be reaching out to you. And I'm giving you permission and authority to talk with and communicate with that party as if you were communicating with me. And that will eliminate from the beginning of the case that will eliminate there shouldn't be any barriers to your person on the outside communicating with that attorney. If you let that attorney know the first time you meet that attorney, if you know someone that is willing to help, then you give that attorney that person's name. If you have a phone number and all that, you can even give the attorney that information as well and tell the attorney to expect to receive a phone call or communication from your person on the outside. Now, once you've done that, you should let the attorney know, listen, I would like for you to, if they're going to be holding you in custody or something like that, and you're not getting out and they're holding you in custody, you let that attorney know, or even if you're not, you let that attorney know that you want a copy of the defense case file. Everything that attorney has on your case is in that attorney's case file with your name and all that. Anything that comes in to that attorney on your case will go into that file. And you want to let the attorney know that he or she is to forward you a copy of everything that's in that file and anything that attorney gets going forward that's going to be going in that file to photocopy it and send you a copy of it. If you're getting out when you get arraigned and you can provide a physical address or an email address, they can email, you don't even need a physical address nowadays. All you got to do is give them an email address and tell them, listen, email me this information to this email address. And when you get it, you can read it, you can print it, you can do whatever you want to do. You save it and you create your own file and you keep those documents in it. And if you're not getting released and they're holding you in custody, then you have the attorney send it to you wherever they're holding you at. And when you speak to whoever you have on the outside that's going to be communicating with the attorney, you tell that person the same thing, to have the attorney send them a copy of the case file, as well as any documents that they get going forward that goes in that case file as well. Now the both of you should have a running current copy of everything that the court appointed attorney that's representing you has. Everybody should have the same thing. Now you can look through those documents and see if anything doesn't make sense, if something is wrong, if something is off. You start looking at this and digesting this information, and maybe you can see something that can some sort of discrepancy or something that can get you out of that situation. But you have to remember, and I think I've mentioned this before during a previous episode, this system is set up to operate off of the ignorance of the defendant who's being accused of a crime, especially if that defendant is black or brown, black or Hispanic. If you're black or Hispanic, the system is set up to exploit any ignorances that we may have as we navigate through the criminal procedure law from arrest until adjudication of the case, whether it gets dismissed, whether you have to go to trial and you're acquitted, or God forbid, you're found guilty. The case has to be adjudicated some kind of way. As the case proceeds through that process, the system is set up to exploit the black and brown individual all along that process. Trust me. How do I know? Because I've experienced it myself firsthand. And this system is so wicked that it'll exploit you even if you know and you're actively fighting and trying to point out, listen, how are you doing this and you have something to counter with that? If it's just a wicked system. I don't want to get it too deep into it right now because today's topic is how to get the most out of your legal aid attorney. Now, what you also want to do is if they're holding you in custody, then I strongly suggest, instead of you going into the TV room and watching TV with everybody else who's in there, or you going to the gym, or you going out to the rec yard and, you just using up your recreation time, your free time doing things like that, I would suggest that you take a moment and you sign up and go to the facility law library. By signing up to the facility law library, you can go in there armed with the paperwork that you get from the court appointed attorney, and you can start doing your own research. You don't have to have some sort of high advanced law degree or college, and all you have to do is have an average intelligence and be able to read and understand what you're reading, and then apply that to your situation, and you should be able to at least have an understanding of what's going on. And if you see conflicts, like, this system is set up to exploit you. Now, let me take a brief moment to tell y'all a true story. There was a friend of mine who found himself in the unfortunate position of being charged and indicted for gang assault, felony gang assault. Now, this happened in New York State. Specifically, this happened in Sullivan County, New York, y'all. For those of y'all who may be watching who are familiar with that neck of the woods, y'all know how Sullivan County gives it up. They willing to get down and dirty, grimy in the mud. They're willing to do whatever it takes to get a conviction. Oftentimes, they don't even care if the person is innocent or truly guilty. They're just looking for that conviction. Anyway, getting back to the story, a friend of mine found himself charged and indicted for gang assault, felony gang assault. Now, the victim of the assault did not identify my friend, and none of the witnesses to the assault identified my friend as being a participant in the gang assault. The only person who was identifying my friend as being involved in the gang assault was someone else who was charged with gang assault. So, in legal terms, that was my friend's co-defendant. In the rules of the law, it's called an accomplice. New York State Criminal Procedure Law 60.22 deals with accomplice testimony and the requirements to admit accomplice testimony in a court of law. Now, the law states that in order for accomplice testimony to be admitted in court, there has to be other outside corroborating evidence, meaning there has to be evidence aside from the testimony that the so-called accomplice is providing. There has to be other testimony that corroborates the accomplice testimony. And in New York State, in order for a felony case to be trial ready, there has to be an indictment, and the matter has to be moved to the proper jurisdiction. In New York State, felony charges are tried in Superior Court. In the 5 boroughs, that would be New York Supreme Court. In any of the other counties outside of the 5 boroughs of New York City, it's county court. So in Sullivan County, it was Sullivan County Court. Now, they had him indicted and ready for trial. They were in a trial posture. But the only evidence they had that even remotely connected my friend to this gang assault was the testimony of someone who admittedly took part in the gang assault. They didn't have anything else. So theoretically, they didn't have enough evidence to get an indictment. But here they are, they had him indicted, and they were offering him a significant amount of state prison time on a plea bargain. So I happen to be familiar with this part of the law because I had to deal with it before in the past myself. So I told my man, I said, listen, this is a case right here where if I were you, I would most definitely, without a doubt, take this case to trial. And I would make sure that my attorney, and if not my attorney, I would even do it myself, stand up and point to the law and point to the accomplice testimony law found in criminal procedure law and tell the jury that, look, they don't have anything else except this so-called accomplice testimony implicating me in this horrendous crime. And I had nothing to do with it. I wasn't there that day, and I would take it to trial. You know, the other alternative is to take the state's offer of significant prison time. So I actually took my man down to the law library, pulled up the relevant statute in criminal procedure law, showed my man the criminal procedure law. We photocopied the relevant criminal procedure law, and my man ended up going to trial, and he ended up quickly being acquitted. and he went home. And he was very happy. He came back to see me. We were both in the Sullivan County Jail at the time. He came back to see me and he took care of me. And this is the prime example of the system trying to take advantage of brown and black folks, take advantage of their ignorance. If you don't know something about the law, this system is 100% up to try to exploit anything you don't know, any ignorance you may have on any particular part of the law that deals with your case. This system is set up to exploit it. Thank God that didn't happen to my man because he was truly innocent. Sullivan County didn't care about whether he was innocent or not. They just wanted to convict him and send him to state prison. So, getting back to the original situation, you want to do the research yourself. You want to do as much research as you can. You can't count on your court appointed attorney to do the research for you. That court appointed attorney is not going to have the time and might not even really care, to be frank with you, about your situation, and might be thinking he'll plead guilty down the road and that'll be that. And I'll get paid, whatever I get paid. Some of them just is going through the motions and they will get paid at the end. They're getting paid along the way. They're submitting paperwork to the courts showing, look, I filed this omnibus motion, I did this, I did that, and they're being paid for it. They're just moving people through the system. And most of the people they're moving through the system are going upstate or ending up with some sort of conviction and some sort of penalty attached to that, whether it be jail time or, in most instances, prison, state prison time. So we have to take the initiative ourselves. If we find ourselves in a situation where we've been charged with crimes and we want to contest those charges, we can't sit back in the TV room or in the yard and not be taking any initiative ourselves to try to work on our defense and expect a court appointed attorney to do that for you. If you're doing that, it's only a matter of time before you're going to plead guilty because 97, 98% of the cases in America end up with some sort of plea bargain. So with those type of odds, everybody could be sloppy. The DA doesn't have to come up with corroborating evidence. The judge who reviews the grand jury presentation can fake it to make it. Oh yeah, everything was on the up and up. There was sufficient evidence. He ruled that there was sufficient evidence presented at the grand jury to sustain that indictment, even though there was no corroborating evidence to corroborate what that dude. The judge can fake it, the prosecutor can fake it with not enough evidence to sustain that indictment, but I'm gonna just get the indictment. I'm not going to explain to the grand jurors that there has to be corroborating evidence. The DA isn't going to do his or her job. The judge isn't going to do his or her job. Your court appointed defense attorney is not going to do his or her job. Guess what? It falls on you, the person that got accused, the person that's accused. It falls on us to do our job and try to get the most out of the court appointed attorney and get all of the documents and do as much research as you can yourself. And maybe you'll find a 60.22 violation if you look through your stuff and find a way out of a situation. He was looking at 20 years. He walked out of the courthouse. He came back. Unfortunately, I was in custody with him and he came back to see me and dropped some money on my books. He's a good friend of mine. I know him from the Bronx, but we were up in Sullivan County and he got caught up in his situation. I got caught up in mine. He came back to see me and he's a good friend to this day. We had to conduct our own research. We had to find the where the weak spot was in the law, and we had to exploit that to our advantage because if we didn't know about CPL 60.22, he would have either taken a plea, more than likely, because he didn't want to do 20, or he would have went to trial and they would have thrown the book at him on insufficient evidence and worked it in a way where maybe he doesn't get the relief on the appeal and he ends up doing, it's a wicked system. So we got to do the work ourselves. And when we find something, you got to it's crazy. You can't, some of these court appointed attorneys are working with the system. There's another friend of mine, he's on Rikers Island right now. I'm trying to help work to get him out of his situation. He's been charged with a felony assault of a police officer, even though he didn't lay fingers on the police officer. They got him jammed up right now, and they're just playing with him. He's been in there for since last year. He's been in there several months, and we're trying to help get him out of his situation. But these are some of the things that we can do if we get charged with an offense, a crime, especially felonies, and we don't have the money or the means to hire our own attorney of our choosing, and we have to settle for the court appointed attorney, then these are some of the things that we all can and should do to try to get the most out of the court appointed attorney. And we should be doing everything we can in our power to conduct our own research. Maybe you got charged with some sort of crime on the street and they holding you in custody, but you have somebody on the street who can go to the scene of the alleged offense and look around. Maybe there's some cameras or something up there, and the cameras, if they could get a hold of the cameras or look at the cameras, they may see that the alleged perpetrator looks nothing like you. And you can't count on a court appointed attorney to do that. You can't count on a court appointed attorney to hire a private investigator to go and do that, even though the state would. And the state might find that evidence, their private investigator might find that evidence. And under law, state and federal law, they have a duty to turn, it's called exculpatory evidence. It's evidence that tends to uh, prove your innocence or mitigate, if you are guilty, it mitigates your punishment. It's called Brady material. Brady versus Maryland, Supreme Court case. I can't remember when it was passed, but it's long-standing law, and they are supposed to turn over this type of evidence to the defense should it fall into their lap. And if they have a PI looking around the crime scene, then they are probably looking for cameras in different places, and they may find a camera that shows what happened, but it obscures the image of the alleged perpetrator. And that's the image that they're using in court, saying that, that's you. But there may be other cameras that were out there as well that may have an image that shows a clear picture of the alleged perpetrator and shows pretty conclusively that that person is not you. And if it doesn't show pretty conclusively, it shows conclusively enough that it creates reasonable doubt. Maybe you weigh 170 pounds and the person in the video weighs 30. You know what I'm saying? You can see that the perpetrator, is much heavier than you are. And that creates the reasonable doubt that leads to a not guilty verdict. But the prosecutor does not always turn this information over to the defense like they're supposed to. They don't care about sending innocent people, wrongfully convicted people, away to prison. And if you happen to be black or brown, you stand a greater chance of stuff like this happening to you. It's just in the numbers. This isn't something I'm making up. This is something that's in the numbers. But if you have someone on the outside who's able to stay in contact with the court appointed attorney, maybe that person or someone else you might have that can go and look at if there's a crime scene in the example that I laid out in this session right here. Maybe they can go look around and see if there are any cameras, any other cameras other than what the people are producing, what the prosecutor is producing, and maybe they can find something that helps you prove your innocence. So we have to be vigilant and we have to take the initiative ourselves to try to do as much as we can ourselves, and we cannot count on the court appointed attorney to do the work for us. So I hope that everyone has gotten something, a little something out of this episode, and we can be reached at the Justice Chronicles, P.O. Box 158, Teaneck, that's Teaneck, New Jersey 07666. If you like this video, please like it, share it, comment. Thank you. Everyone be safe.